Okay, so we're back. I apologize for not being able to show the PowerPoint on this platform. And so I emailed it to everyone on the meeting and they can go through it, but I will discuss it openly so those can hear and understand what we're talking about. The first slide we're looking at is questions on state powers. State powers being what the Constitution has granted the state authority to do. The Arizona Free Enterprise Club has been pushing and successfully pushed the legislature to pass HCR 2039, which is Prop 135 for the state of Arizona. We will be voting on this in November 2024. This proposition is actually misleading the public, but what it is doing, it is adding a section in the Constitution that grants emergency powers to the governor. The governor does not have emergency powers under the Constitution today, and the legislature has no emergency powers themselves. And what I'm going to do is go through and discuss what this proposition does and why it's a violation of many sections of the Constitution and a Republican form of government entirely. A Republican form of government is a representative form of government, which means we have representatives that we elect that work for the people. The governor does not work for the people. The governor is the executive of the state, has no executive power over the people. And that's clear if you read the powers of the governor under Article 5 in Arizona's Constitution. So let's go and discuss this Proposition 135 briefly. It's wrong for Arizona in that right now, currently, we have laws that allow the governor to make law through orders, policy, and directives. Basically, it's governing by proclamation. The governor can currently force vaccinate, illegally detain, house, and hold a citizen without due process of rights. That's under law right now. And I'll go over those laws and show you and explain them to you. These laws violate many sections of Arizona's Constitution and are not in balance with the 2016 Republican platform. No Republican would support this and should be removed from office. That's my opinion. Current laws should have been rescinded rather than an attempt to legalize the laws through Prop 135. What I'm saying is the laws on the books are unconstitutional. What should have happened is the legislature, if they were really working for the people and defending the rights of the people as they're mandated to do, they would look at those laws, which I have been telling them since 2000 when the whole COVID started, that they're unconstitutional, but they wouldn't listen to me. So instead, what they did is they passed HCR 2039, which is now Prop 135, for the people to vote and make them legal by adding it to the Constitution. I want to just state something real quick that in one Federalist paper I want to point out at Madison in Federalist 46, the federal and state government, this is slide number 3, are in fact but different agents and trustees of the people, constituted, with different powers and designed for different purposes. The adversaries of the Constitution seem to have lost sight of the people altogether. The adversaries of the anti-federalists, they believe that the Constitution gave too much power to the federal government and left not enough for the people or the states. But he's saying that the adversaries believe that they lost sight of the people in the reasonings and on this subject. And to have viewed these different establishments, the state and the federal, not only as mutual rivals and enemies, but as uncontrolled by any common superior in their efforts to usurp the authorities of each other. So when the state and the federal government battle each other for power and that they do not have, and that's a usurpation of power from one or the other. So these people, these gentlemen must be reminded, those that are adversaries of the Constitution must be reminded of their error. They must be told that the ultimate authority wherever the derivative may be found, resides in the people alone. That is us, folks. We have to stop giving our power and authorities over to the government and trusting them when we can obviously see what they're doing is such a disaster. So it resides in the people alone, and that it will not depend merely on the comparative ambition or addresses of the different governments, whether either or which of them will be able to enlarge its sphere of jurisdiction at the expense of the other. The people are the ultimate authority. I want to make that clear, us. So Arizona Constitution, Section 2, when you're looking at, pull it up on az.gov, go to the legislature, and then pull up Constitution under state government. Arizona Constitution is on there. Section 2 is our Declaration of Rights. Section 2, Article 2, but Section 2 is political power, purpose of government. When we're looking at these laws that are on the books and we're looking at these propositions that they're misleading you to vote for, understand this. All political power is inherent in the people, and governments derive their just power from the consent of the governed and are established to protect and maintain individual rights. That is law in our Constitution, and I've read many state constitutions, and it's in each and every one of those that I've read as well. We have the political power, not government. It is inherent in the people. It says so in the Constitution. It says so under Article 2 of the Declaration of Independence. So if we understand this, it's much easier to know what we're talking about when we're looking at these propositions or laws. Now I'm jumping down to slide 15. Currently, under Arizona law, now this one I think I can share. Let me see if I can do this. Can you see that? ARS 26303?
Yes, we can see it.
Okay, excellent. So this is a current law. ARS statute 26 are emergency powers, and 36 are the actions we authorized, or the state legislature unconstitutionally authorized the governor to do during emergency powers. So here they're talking about emergency powers of governor, terminating authorization for adjutant general, limitation, extension, report, notices, and appeals. Okay, this is authority that they granted to the governor that says during a state of war emergency, the governor may. There is no such thing as a war emergency. The governor doesn't declare a state of war emergency. There's no authorization for that. That's under Article 5, Section 3, 4, and 5 of the authorities granted to the governor. It's not there, and they cannot assume any power that's not granted to them. So they can suspend the provisions of a statute. So they're granting power to the governor to suspend law, prescribing the procedure of conduct of state business. So any license, that's where under COVID, when the State Bureau of Alcohol and Tobacco went in and started suspending people's licenses because they wouldn't shut down, giving them notice, a bar. COVID's so smart, you serve more than 50% of alcohol. So COVID is going to be attacking your license, so you need to shut down. And then, but if you're a food establishment serves more than 50% of food, you can stay open, but you got to cut your business seating down 50%. It's ridiculous, but this is that's an example of what the governor has the authority to do under this unconstitutional statute. So they can suspend orders. The governor can determine and proclaims that strict compliance with the provisions made at any provisions of any such statute, order, or rule would in any way prevent, hinder, delay mitigation of the effects of the emergency. Now, I'm going to explain to you who's responsible during an emergency later. The commander, they can commandeer and use any property except for firearms, ammunition, and ammunition components. They can commandeer your property. That is a taking. That's a violation of the eminent domain. The only way they can take your property under the law of the Constitution is if it's needed for easements, roadways, or for public good. And they have to go to court, they have to show the need for it, and they have to compensate you for it. This takes all that away. It just gives the power of the governor to do whatever they want. This is like living under the king. Let's see, what is the next one? The powers granted the governor of section C, let's go B. During a state of emergency for war, the governor shall have complete authority over agencies of the state government and shall exercise all police power vested in the state by this Constitution. Well, guess what? The Arizona Constitution, nowhere in there does it convey police powers. So where are they getting the police powers from? Article 2, Section 2, all political powers inherent in the people. We have that. We granted police powers to maintain peace, to protect and preserve our liberty, not to take it away. Okay, I want to jump down here to G. If you jump down to G right here, if you see what I'm highlighting, beginning January 2nd, 2023, the governor may issue an initial proclamation with respect to a state of emergency for public health emergency as described in section 36,787. We'll go to that. Let me write that down so I can bring it up. Okay. For a period of not more than 30 days. Wow. It's already a law. It's illegal. It's unconstitutional law, but it's already a statute that says it's limited to no more than 30 days. The governor may extend the state of emergency for not more than 120 days. So now there's 150 days, almost 5 months. But any extension may not be for a period of more than 30 days. So if the governor today wants to declare a state of emergency, it's for 30 days, and they can extend an additional 30 days up to another 120 maximum. The legislature may extend a state of emergency. Whoops, did I skip something? Okay. The state of emergency shall terminate after 120 days unless the state of emergency is extended in whole or in part by passage of a concurrent resolution of the legislature. So when the governor's time is over destroying the state, the legislature can continue it on their own in violation of the Constitution, in violation of their mandate to maintain and preserve individual rights. The legislature may extend a state of emergency as many times as necessary by concurrent resolution, but any extension may not be for a period of more than 30 days. If a state of emergency, public health emergency is not extended pursuant to this subsection, the governor may not proclaim a new state of emergency based on the same conditions. So there you go. That's cool, but it's illegal. They have it even for 1 day. H, on the extension of a state of emergency for public health emergency pursuant to subsection G of this section, the governor shall submit a written report to a joint committee of the health committees of the Senate and the House of Representatives or their successor committees. So what? After the first 60 days of public health emergency, the director of the Department of Health Services, as representative of the governor, shall provide a briefing to the joint committee. This makes no difference to me because they shouldn't have it at all. If authorized by the governor under J. Oh, there we go. I. This chapter does not limit, modify, or abridge the powers vested in the governor under the Constitution of the state, statutes of the state. Yes, it does. It expands them. It doesn't limit, but it modifies it by giving them more power that they don't have under the Constitution. That's a lie. Exercise those powers pursuant to the statute of the gubernatorial authorization following the proclamation of state of emergency under subsection D of this section. 2, this is the adjutant general. This is the individual that they put as a civilian over our military of the state. Incurs obligations of $100,000 or less for each emergency contingency plan, so they get $100,000 right away. But basically, I want you to know this is already in law, that it's a limit of 30 days with an extension to 120 days. They don't have the authority to make a law like this. it's unconstitutional, it's unauthorized, and they need to rescind those laws instead of making a law granting more authority to the governor. Now, let me go back to this here. 26303, the governor has complete authority over all emergencies, all agencies of the state. We talked about that. Okay, ARS 631. This is important because not only does it grant powers to the governor, but the county and the state. This will continue the unconstitutional laws on the books today. What did I say that was real quick? 6311, ARS 6311. Okay, I'll just read it. It's important that you know local emergencies. So if once a governor declares a state of emergency under ARS statute 26311, already a current law on the books, became law 2022-23 during that 2022 session 2 years ago. Local emergencies, declaration by mayor or chairman of the board or power of a political subdivision. So if a mayor or an incorporated city or town or the chairman of the board of supervisors for unincorporated areas of the county deems that an emergency exists due to fire, conflagration, flood, earthquake, explosion, war, bombing, acts of the enemy, or any other natural or man-made calamity, disaster, or threats, the mayor or chairman of the board of supervisors, if authorized by ordinance or resolution, that's important to know, may declare by proclamation an emergency or local emergency exists. So what that means is that if they have it in their charter when they become a city or a county, or they pass an ordinance that allows the chairman, the board member, the board chair, of the county, or mayor of the city, they independently of any meeting and having a city open public meeting can declare state of emergency. And now they can modify all existing laws or set them aside if they determine that those laws get in the way of their needed action for this emergency. Does that make sense to you? No. It's illegal. So now we are being governed by proclamation just because they think it's a state of emergency. The next slide is ARS 311, local emergencies continued, that same statute. Pursuant to subsection A of this section that I just read you, this is B, the mayor or the chairman of the board of supervisors shall govern. That's mandatory. They have no choice. Now they are now determined to be a king. Thank you, our Republican legislators. Shall govern during such an emergency by proclamation. Whatever they say is now law. And shall have the authority to impose all necessary regulations to preserve the peace and order of the city, town, or unincorporated areas of the county, including the ordering of the closure of businesses, including the following. Let me see if this is what we want to do. Okay, I didn't put that in there, but basically, they have the authority to shut businesses down. They have the authority to commandeer property, whatever they choose to do, close roads, all that stuff, confine you to your house, make you a prisoner of your home. This is an interesting one. This is also a violation of the Constitution. ARS 26314, immunity of state, political subdivisions and officers, agents, employees, and emergency workers with limitations and rules and definitions. So here we go. A, 26314A, you can look it up. This state and its departments, agencies, boards, and commissions, and all political subdivisions are not liable for any claim based on the exercise or performance or the failure to exercise or perform a discretionary function. So there's no discretionary function allowed now. It's all by mandatory proclamation of the mayor, board of supervisor chair, or the governor, or the failure to exercise or perform a discretionary function or duty by any emergency worker, law enforcement, EMT officer, fire department, except for willful misconduct. Well, that we have that now, or gross negligence or bad faith of an emergency worker in engaging in emergency management activities or performing emergency functions pursuant to this chapter or Title 36, which is the next series. Chapter 6, Article 9. So basically what they're doing is they're granting immunity for any civil wrongdoing if they harm you, for mandating that you take a shot, for separating you from a loved one, because they can do that. We had hospital kidnappings when they're in a hospital. Well, now CDC guidelines says they can't have any visitors. You're taking away the advocate for that patient to look over them and make sure they're not being mistreated, abused, or murdered. Here's another one, 26.316, enforcement of orders, rules, regulations. This grants the power to the governor that says whatever they say, or the board of supervisor or city, this is law now, 26.316, enforcement of orders, rules, and regulations. The law enforcing authorities of the state and political subdivisions shall, that's mandatory, enforce orders, rules, and regulations issued pursuant to this chapter. The normal process for making a law that restricts or takes away the civil and liberties of an individual go through a process. That's a checks and balance to make sure that your rights aren't being violated. It goes through committees in the House and the Senate. It goes through the law committee, procedure committee, all the committees it has to go through, and then it goes to the governor to sign. If the governor says, hey, something's wrong with this, the separation of powers and the checks and balances, the governor has the right and an opportunity and a duty to veto that. Say, no, this goes too far. That's a process. We're taking all that away. That is what they call a representative form of government, a Republican form of government. They're stripped that away with these laws. Whatever the governor says, or the mayor, or the board of supervisor chair goes. And the law enforcement's mandated to enforce it, which is, they're not enforcing law. What's the key word of law enforcement? Law enforcement. It's not a law. It's a proclamation by a governor that's not been gone through the natural processes and care to make sure that it doesn't violate constitutional rights. Violation classification. Any person, 26.317, read these, folks. 26.317, any person who violates any provision of this chapter or who knowingly fails or refuses to obey any lawful order, it's not a lawful order. They can't lawfully order you to do anything unless they're saying, hey, don't go into that burning house. Well, that's common sense. Yes, they can do that. But a lawful order is not a lawful order if they say, hey, you're confined to your house, which is a custody without due process rights, 4th, 5th, or 6th amendments, and they're forcing you to stay in your house. That's not a lawful order for 2 weeks, like the governor did, or a curfew, like he did, 8 p.m. That's not a lawful order. Shall be guilty of a class 1 misdemeanor. Well, what provisions were taken care of to make sure this is lawful? This law is legal and doesn't violate the Constitution? None. This provision does not apply to the refusal of any private organization or member thereof to participate in a local emergency or state of emergency as defined in this chapter. What does that mean? They don't have to participate? Does that mean, well, hey, this emergency, because I'm a member of this private organization, doesn't apply to me? Or our organization is not going to participate in assisting you? Or our organization is not going to participate in any confinement laws or social distancing? What does that mean? It's ridiculous. The next slide is public health authority during state of emergency. During a state of 36,787, you're going to love this. During a state of emergency or a state of war emergency, which also is not necessary, not in the Constitution, proclaimed by the governor, in which there is an occurrence or imminent threat of an illness or health condition that is caused by a bioterrorism, epidemic, or pandemic disease or highly fatal infectious agent or biological toxin, and that possesses a substantial risk or significant number of human fatalities or incidents of permanent or long-term disability, the department shall coordinate all matters pertaining to public health emergency response of the state. Well, some of this is fine. There are times when, yeah, let's deal with this, but it's not by restricting and violating the rights of the people. Why is this such a threat? Well, look at the WHO treaty, giving them authority to declare a state of emergency. They want that. And they're already talking about, well, monkeypox is a real threat and it's coming out of Africa and we need to declare an international state of emergency. So now let's say they do that. And now we have the CDC, a representative from the CDC, I forgot his name. I was watching the video the other day where he says, what authorities should we use, not can we use, but should we use to enforce mandatory vaccine or lockdowns? And he even brought up, well, should NATO be one of these agencies? Are you kidding me? Where are we going as a society like this? 787 again, section C, public health authority during state emergency. If the governor believes there is an occurrence or the imminent threat, and this is, I just have one more after this and I'll call it quits. Imminent threat of smallpox, plague, viral hemorrhagic fevers, or highly contagious or highly fatal diseases with transmissions characteristics similar to smallpox. It's interesting they use hemorrhagic fevers and smallpox because that's one of the things that they were concerns of a threat coming out. The governor, in consultation with the director of Department of Health Services, may issue orders that mandate treatment or vaccination of persons who are diagnosed with illness resulting from exposure. Okay, you've been exposed and you have it, or who are reasonably believed to have been exposed. No evidence you've been exposed, but because you were in a room with people who had it, you may have been exposed, so we're going to count you in, or may reasonably be expected to be exposed. So in other words, if you're at home and you leave your house to go to the gas station, well, they got you there too, because in their mind, it's reasonably to expect you could have been exposed. So now you're under their authority. A person who may refuse a vaccination required in this paragraph based on the person's personal beliefs, but isolate and quarantine persons. They can still, law enforcement officials of the state and National Guard shall enforce orders issued by this governor. So here, what are the exceptions to that? So you can refuse based on your beliefs, but here we go. Due process for isolation. I'm sorry, there's one more after that. Due process says that if you're part of a group that they believe may be exposed, or you're part of your family may have been exposed, or you as an individual may have been exposed, they can isolate or quarantine you. An individual, if they have their due process rights, I get it. Typhoid Mary is a perfect example. She was cooking food, had typhoid, and contaminated people, and some people died. They told her, no, stop cooking food. As long as you stop cooking food and serving people, there shouldn't be a problem. That was their rationale. That was their reasoning. She continued to do that and killed more people. Finally, they said, look, you're not cooperating, so we're gonna detain you. She was detained for the rest of her life because she was a carrier for typhoid and she wasn't following rules. I get that. That's no different than somebody standing out in the middle of the street and shooting a gun off into the air or into buildings. You're a risk to society. You're not cooperating. We're here to protect the rights and safety of each individual from people who are violating your rights. You have a right to be healthy and safe from other people acting stupidly or not following specific mandates as an individual. I get that. However, when you have a group of people and they just suspect you may have been contaminated or exposed, they can quarantine you. Here it says, 36789A, the Department of Local Health Authority may isolate or quarantine a person or group of persons through a written directive. No court. They just direct. You're detained. Your whole family, the whole neighborhood is detained without first obtaining a written order from the court. That's mandatory. In any criminal case, there has to be a warrant and a written order from the court for detention or arrest, unless it's a crime during an investigation or they see a crime, an officer witnesses a crime committed in their offense. That's different. But this is just a written directive of a health official who graduated school learning how to take temperatures and check your pulse. They can quarantine if the person would pose an imminent threat or serious threat to the public health. This is left to the health department official to determine. So all they have to do is do a written directive to you. Now, hold on. If a number of people makes it impractical to serve each of them, a notice of the order can be placed on a wall in a conspicuous place of the premises where you're all gathered and housed. So there's your notice. We'll put a notice on the wall and you go read it. They must file a petition in court within 10 days of the detention. So they're admitting you're detained. But we have 10 days to file a petition showing that we got these 100 people, 200 people, whatever it is, detained 10 days later, and the court has 5 days to get it on calendar. When I was arresting people, if we arrested someone, we had to have them filed on within 24 hours and in court 48 hours later. If they're detained. Here, they got 10 days, and you didn't commit any crime. If good cause showing, the health department can ask for a 10-day continuance. So you could be in custody for nearly a month before any court appearance. And are you all going to go to court? No, it'll be televised. Constitution sections violated. This is a whole section because we're sharing with people that can't see all this. Just know there's 13 sections. Article 2, Section 2, political power, purpose of government. That's where all political powers inherent in the people. They derive their just powers from the consent of the governed. And the purpose of government is to protect and maintain individual rights. Due process of law, that's violated, we just discussed. Right of petition and assembly. We have the right to petition our government for redress of grievances, which means it's a discussion. They don't just sit there and ignore you. And of assembly, we have a right to gather. We have a right to go to church. Freedom of speech in the press, that was suppressed. Article 2, Section 6, Article 2, Section 7, oaths and affirmations. They take an oath to uphold the Constitution and defend it to the best of their ability and the U.S. Constitution. They failed that miserably. Article 2, Section 8, right to privacy. You have a right to your privacy. Article 2, Section 9, this is of the Constitution, by the way. Irrevocable grants of privileges, franchises, or immunities. They cannot grant immunities, which they did. I read you that section. Administration of justice. That says Article 2, Section 11. Court shall be open. All justice shall be done openly. When there was court, they did not allow people in the courtroom except for the defendant or a few witnesses. The people were not allowed. That is open court. The people appear in court to ensure that there's no kabuki theater going on, that the individual's not being railroaded, that they can watch justice being served, because justice is to serve society, not the Justice Department. But they violated that because they closed all courtrooms on order of the Arizona State Supreme Court Justice, who doesn't know the Constitution, obviously. Number 9. ARS or Constitutional Section 2, Article 13, Section 13, equal privileges and immunities. No law shall be written that grants privileges or immunities to a corporation or an individual that are not granted to an individual or corporation on the same or equal basis. They closed businesses based on what they thought was appropriate for them. Oh, you're a small mom and pop business, you got to close down, but Sam's or Costco can stay open, or Walmart, and have thousands of people go in and out there every day. Where's the logic in that? It was designed to kill and destroy small business. Now, how is that free enterprise club finding that free enterprise when they destroyed 50% of the small business that closed, forced to close, did not reopen? Not very free enterprise, is it? Hey, military power, subordinate civil power. I didn't get to that section because it's a time-consuming process, but the ARS statutes provide a section there that allows the governor to call forth the National Guard to enforce his orders. Well, right here, military power is subordinate to civil power. The military has no authority within the boundaries or the state of Arizona or any other state. Article 1, Section 8, Clause 15 is the militia clause under the U.S. Constitution. That says that Congress shall have the power to call forth the militia to to enact the laws of the nation, suppress insurrection, and repel invasions like we're having now. Who does this? The militia. Who's the militia? The people. A well-regulated militia being necessary to secure the safety of a free state. The right of the people to be armed shall not be infringed. Arizona's Constitution, Article 2, Section 26, a citizen's right to be armed in defense of themselves or the state shall not be impaired. Who's called forth during times of crisis? The militia, the people. They're suppressing all of us with this nonsense. And by giving authority, the Republican legislature, thank you very much, giving authority to the governor to call the militia, to call the National Guard out, which is the military of the state, under Article 5, Section 2, the governor shall, I think it's 1, the governor shall be the commander-in-chief of the military of Arizona. Well, they're subordinate to civil power, and he's using them to enforce it on civil power. Insanity. Article 2, Section 32, constitutional provisions are mandatory. And number 33, which is just like the 9th Amendment of the U.S. Constitution, reservation of rights. Just because a right's not listed in the Constitution does not deprive or deny those retained by the people. Just like under Federalist 46 with Madison, they seem to forget that all the power lies with the people. And we're stripping that away. Distribution of powers. Arizona, Article 3. 3 branches of government, where they call them departments. 3 departments: legislative, executive, judiciary. Not one department shall exercise the authorities of another. Yet they're violating distribution of powers, Article 3, powers to the governor to make law and enforce law. And the legislature has no authority to do that. They violated Article 4, Section 25. Article 4 is for the legislature. Section 25 is the only section that talks about emergency, and it's not a power. It's something they're mandated to do, and that is provide for the continuity of government. This is slide 27 for you. Continuity of government operations in an emergency. What does that say? That if we have, and that emergency happens to be during enemy attack. That's the emergency. And their mandate is to provide for a continuity of government, that it continues during that emergency. And they do it by 2 things. Number 1, they can do it by delegating the powers of an agency to another agency if that authority that oversees that agency has been captured, killed, or unavailable. So it has to continue. So they say, hey, we're now going to provide DPS, Department of Public Safety, over to some other department to carry that on. So they transfer it, or they can fill the vacancy of the department head that's unavailable by appointment. That's it. There's no authority over the people. That's the only constitutional section that grants any mandate for them to do anything during an emergency. And that's it. Nothing over the people. It violates Article 5, Sections 3, 4, and 5. Article 5 is the governor, and that's the specific sections that gives him his authorities. Guess what's missing? Declaration of powers. They want you to add that to the Constitution. Thank you, Amy Yentas, and the Free Enterprise Club and the Republican legislatures that all pushed this. Sections violated, no authority continued. Articles, this is a big one for me too. Article 27 of Arizona's Constitution, Section 2A, to preserve the freedom of Arizonans to provide for their health care. Wow. A law or rule, Article 27, Section 2A, number 1, paragraph 1. A law or rule shall not compel, directly or indirectly, any person, employer, or healthcare provider to provide any healthcare system. Okay, what's a system? For the purpose of this section, lawful, this is Section 1D, number 4, D4, lawful healthcare services means any health-related service or treatment to extend that the service or treatment is permitted or not prohibited by law or regulation that may be provided by persons or businesses otherwise permitted to offer such services. So they can offer it. The government can clearly say, hey, look, we got this shot. I won't call it a vaccine because we know it's not. We got this shot and we believe that it may help you. Wink, wink. You're free to take it if you want to. They can do that, but they cannot mandate it. And that's exactly what they did. It's a violation of Section 27, Section 2, or Article 27, Section 2 of the Constitution. If we need any more proof, just go through and read these things over again and look at the sections that I didn't cover under 37 that talks about how the governor can mandate your incarceration in these things. And then look at the CDC, green protection zones, or whatever they call them. There's all kinds of things out there that they're working in cahoots with the federal government, who has no authority over the states, by the way. So I'm going to stop here and let's open it up for some questions. I hope you took some notes, but we got 3 of you on board here. I'd like some discussion on this so we can find how can we get information out to the people? How can we articulate? I'm going to post this video being recorded so people can watch it, and I'm hoping we're not going too long. I know I can be long-winded, but I'm going to stop, and if anyone has a question, Susan Black, Susan Elworth, Jeff, you'll have to unmute yourself. Hello, anybody there?
Can you hear me?
Yeah.
Randy, can you hear me?
Yes.
Oh, hey, Susan Ellsworth, Jeff Greenspan. How are you?
Hey, good.
So Randy, we want to get to the so therefore what, right? So therefore, why do we need to oppose this in the Constitution? Let me get this all out, right? And my read of Prop 135 is exactly what you said. Now they're putting it into the Constitution, reference to a governor's emergency powers, and then they have that 30-day review or 30-day termination. I think there's some language about notwithstanding other emergencies. So the governor could theoretically, for my read of it, just declare another emergency, and then another, and then another, and then another, and another. And during that time of any one of the emergencies, let me give an example, they can authorize the schools to vaccinate children without informed consent or permission from the parents. And we saw that just the Supreme Court case in Vermont just this past week or two, where the Vermont Supreme Court ruled that schools could do that, and it is constitutional. Why? Because that power is allowed to the executive branch in the Vermont Constitution. And it's also allowed in the New York Constitution. And now we're proposing it in the Arizona Constitution. So yay for a 30-day review. But like you said, all of a sudden they're constitutionalizing statute, which is questionable in the first place. And under statute today, while it might be a long slog, theoretically you could take it to the Supreme Court of the state and they could rule in your favor for all the reasons you gave. But if they put it into the Constitution, and that vaccination, forced medicine, detainment, or freezing your bank accounts and replacing your money in CBDCs during that 30-day period, and you take it to the Supreme Court as a damaged person, what's the Supreme Court going to say? Did it happen during that 30-day period? Oh, it's constitutional. Sorry.
Well, actually, it's not. Even though it's in the state constitution, it's still a violation. Why? What does the U.S. Constitution say under Article 4, Section 4?
Well, the Supreme Court of the state doesn't rule under the national constitution.
Oh, yes, it
It
does.
evaluates the state
Article
one.
4, yes, it does. Article 4 is agreements among the states. And the agreements among the states are these United States. These United States. It doesn't say Congress. Congress shall. It says the United States. The United States.
Yeah, I'm talking about an Arizona citizen bringing suit against Arizona or the governor.
Let me finish, please.
Yeah.
You didn't let me finish. The United States shall guarantee each state a Republican form of government. Now, when you put in your constitution that grants authority to the governor to make law unrepresented and to enforce law unrepresented, you violated a Republican form of government, because a Republican form of government is a representative form of government. You cannot violate that. We will guarantee each of us that we will maintain a Republican form of government. Why? Because we are not a democracy. We are a representative government.
You can see they're doing it anyway, right? So the point is that the Supreme Court of the state, right, will review questionable statute against what's in the state constitution.
That's your
but
assumption.
if it's in the state constitution itself, they will just rule it constitutional under the state constitution.
That's for those that don't understand the symbiotic relationship between the constitutions. Who enforces?
And you just said
who enforces?
You said the state Supreme Court justice. You said the state Supreme Court justice doesn't know the U.S. Constitution.
They don't know the state constitution. They don't know the U.S. Constitution as well. No, they violated it. Because what we have is we have a justice system that is compromised.
I understand. So where I'm going is Clint Bollock, right? He will. No, he might not rule in your favor, but he will entertain a question of a questionable statute versus the Constitution. What's in the state constitution? But if we put this into the state constitution, he will not entertain the question. He'll say it's in the Constitution. Sorry, you're out of luck. That's the danger of Prop 135. That's the danger of Prop 135.
It is a danger because of the ignorance of society and the ignorance of the fact that that makes us a socialist or communist country, because we're no longer represented. And the Constitution, legally, by its foundation, if all political power is inherent in the people, this constitutional amendment didn't change that. And if the purpose of government, if they derive their just powers from our consent, if we vote to put that in, well, obviously the majority that is uninformed and ignorant of what our Constitution is and what their liberty, the foundation of their liberty actually is, will vote for it. And they deserve what they get. That's all I can say. I'm gonna build on that for you. It's not just that they're ignorant, that may be true, but they're openly propagandized into believing this is something other than what it actually says. So yes, that it puts them into ignorance. That's
right, but they're using 10,000 words of Pharisaical argumentation to say that it's not putting it in the Constitution when you just read it and it puts it in the Constitution.
And this is due to the efforts of Arizona Free Enterprise Club and Amy Yentes. For some reason, they think this is wonderful. And I think that they're compromised themselves. You cannot trust an organization or an individual of an organization who believes that we want the governor to declare a state of emergency, to strip you of your civil liberties and your civil rights for as long as 30 days. Especially after what just happened with COVID. They're selling it on to the idea of the people that, no, we're just limiting the authority for 30 days.
It's a Trojan horse. It's a Trojan horse. It's the same power that Vermont has in its constitution. It's the same power that the people just got ruled against when they tried to bring suit. It's the same power Governor Hochul has in the New York Constitution. they're Trojan horsing it through a bunch of Pharisaical arguments here in Arizona and shoehorning it into the Arizona Constitution by saying, oh, but it'll be reviewed in 30 days.
So
but it's the same power.
But the people have to recognize it is a Trojan horse, it is a lie, and they have to vote against it. And what they also need to understand is, at our county annual meeting we had in January, I drafted a resolution explaining briefly what this is and that we will not support it. And the Maricopa County Republican Party voted to not support this. So every legislative district in Maricopa County must, on their golden ticket, say, not oppose. Vote no on Prop 135. Vote no on Prop 135.
Did you name the HCR 2039 in the resolution that passed, Randy? I want to go look it up and send that out to everybody. Okay.
I did. Yeah, thank you. Specifically. And we have to go back to the Maricopa County meeting email that they sent out where they said these are what was passed resolutions, and we need to they need to send that out again. We elected the county leadership for that purpose, and they need to
take that. Since I'm one of those county leaders, I will take that and make sure it happens.
Thank you, sir.
Thank you, Jeff.
You're welcome. My pleasure.
Susan Ellsworth, do you have any questions?
Believe it or not, Jeff brought up a lot of my questions, and the only thing that I'm saying is we just got to find a way to make this very sweet and simple so that we can send it out via digitally via text to people within our own precincts.
Yeah.
Because it's not going to be just the people that are considered Republican. This is a violation of American rights.
It's a violation of every individual citizen in Arizona. Yes.
Exactly.
Yes. This is not a party issue. This is a liberty issue. And remember, CDC has no authority over us either, but they took complete control. They took control of people's property rights by putting forth a mandate that you couldn't evict people. Where in the hell does the CDC have any authority to do that? Oh, and by the way, Debbie Lesko, who's now going to be running for Maricopa County District 4 Board of Supervisor, she voted to support that. She was the only Republican legislator in Arizona for this Congress, a congressman, out of the 9 that voted for it. Or the Republican, out of the 4 at the time, there were 4. All the others voted against it, not her. But so we have people that are going to be on the Board of Supervisors, her being one of them, that's going to just follow orders. No regard for the rights of the people or what their function is while they're in office. Anyway, I really wish I could have shown the PowerPoint while we were doing the presentation so it flows better. If there's some way I can put it in the notes or when I post it so people can pull it up, I'll do that. I mean, I'll see if I can do that.
Randy, would you be open to, on next Tuesday's call, this one ran long, like it really ran an hour. Would you be willing to re-record this and see if we can get it down to a 30-minute presentation?
Yeah, we can try to do that. Like
I think 30 minutes is digestible. I think an hour is not.
Yeah, but I wanted this recorded. You know what? Let me stop recording now, folks. This and then we'll talk. This presentation is for everyone. Doesn't matter what states you're in. Your state constitutions need to be understood and read, and you need to modify anything in there that strips you of your Republican form of government and grants powers as a king or queen to the moronic governor who's going to use it to their advantage to control and destroy. That's not what we are. We're not a Marxist government. We're not a communist government. We're not a socialist government. Not intended to be, but we are, unfortunately. So I hope you get something out of this recording. And I thank you, Susan Black, Susan Ellsworth, and Jeff Greenspan for joining us. And I'm going to end the recording now and then we'll talk, okay? Thank you.
Thank you.
Slide 7.